I rise to comment on this bill, but as I do so, I'd like to start by acknowledging a loss to this country and indeed to Christchurch, as well as the rest of the country today, with the passing yesterday of Bevan Tipene Matua of Ngāi Tahu, Ngāti Kahungunu Rangatani in Raukawa. And Bevan was a Green Party member, but also a passionate educator who worked many years in Christchurch before he went back to his home in Porongahau, and was also the first Māori Research Fellow at the Crop and Food Research Agency with a special interest in intellectual property, plant variety rights and tikanga Māori. And he is a huge loss to education, to his hapu and whānau, and to the country as a whole. So our hearts go out today to the whānau at Porongahau. It is a loss for the Green Party, and it is indeed a loss for us all, and especially for his whānau and his tamariki. However, returning to the Christ College Canterbury bill, I'm rising to speak on this because we're actually voting against the bill based on our view that it is not actually well drafted and lacks sufficient checks and balances when seeking to change the trust deed. In the past, we have supported private legislation to expedite the handling of trusts held by the Anglican, Presbyterian, Catholic and Methodist churches, and in all the previous cases we supported that legislation through the House. The tests contained with this Act closely resemble those found within Part 3 of the Charitable Trusts Act 1957, except that any change does not require High Court approval and are therefore considerably cheaper to implement, and the tests are sufficient. However, unlike previous legislation, this legislation does not contain significant checks and balances when changes to trust deeds are made. For example, sections 10 to 13 of the Methodist Church of New Zealand Trusts Act 2009 provides significant public accountability measures, including oversight by the Attorney General in section 12, and this bill has no similar protective checks or balances. It's unfortunate the school needs to move legislation through the House, itself an expensive process, merely to better expedite the use of property entrusted to them. Christ College has a highly specific mandate when compared to mainstream churches, but the power entrusted to the board must nevertheless be balanced by good process. Is this legislation in the best interest of the school's beneficiaries? Mostly yes. But this is bad law, and we will have little opportunity to improve it because we have no one on the select committee. We are also concerned that the government gave $35 million to private schools at a time when there have been cuts right across the board to the public education system. Even worse is the national standards debacle linked with private schools. Private schools such as Christ Colleges have resources that many public schools can only dream about. The risk of league tables from national standards may help the private sector schools because they may look good to some parents who can afford to abandon struggling public schools. However, this reduces the community to individuals buying education if they can afford it, rather than maintaining and building social equity through a strengthened public system. The Green Party firmly opposes any undermining of the public school system in favour of the private system. The entrenchment of educational inequity and the measuring against a rigid educational standard will not address this problem. Another question we have with this bill is a deeper question about the benefits to mana whenua. How many impoverished tamariki from local hapu benefit from this school in their rohi? Given that there are major questions around the Kemp purchase and Te Wai Pounamu, we can never assume all land sales to the Crown, and then in this college's case to the churches for private schools, can be described without the slightest taint of inequity, and have mana whenua been consulted on this bill? So while Christ College and some other private schools may benefit with issues such as league tables, we're not concerned about protecting their business. We are committed to protecting vulnerable children for whom education is a struggle, and in supporting schools which do their best with very little. I will never forget when I was a lecturer in many schools, visiting a wealthy private school whereby the students were provided with wetsuits to do kayak training on heated swimming pools as a matter of course, and had a library DVD screen that took up a whole beautiful wall. Whereas last year I visited some students at a public school near Wellington, and at this high school the students said to me, do some schools actually have a swimming pool? The gap is already big enough in terms of resources between public schools and the wonderfully resourced private schools that I've referred to. We don't need to increase that gap. So although we're not supporting this bill, we are taking this opportunity to say that we challenge the private school system in terms of the benefits and privileges it occurs on those who have access to it. And we demand that the government puts its energy and emphasis on maintaining and strengthening the public school system. We have raised legal and technical points which may be addressed at Select Committee. We won't be there to raise those concerns. But at a deeper level, we want to stand for a public education system that benefits all.
Time has expired.
Thank you.